Webcast is now starting. All attendees are in listen-only mode.
Hello and welcome everybody to the first PHRN Webinar Wednesday for 2020. We're starting this year with a series of talks that were given at our 10-year anniversary symposium at the Sydney Opera House last November. And we're really excited that some of the speakers from that symposium have agreed to come and give their presentations in webinar form so that more of you have got the opportunity to hear the fabulous presentations that we had at the end of last year. First up, I'd like to introduce Carolyn Adams, who's a senior lecturer at the Macquarie Law School and also a long-term friend of the PHRN. She was one of the inaugural members of our Ethics, Privacy and Consumer Involvement Committee in the early years of the PHRN, and she's also been a fabulous friend and long-term colleague of mine, so I'm delighted to have her come and talk to us today. She's going to talk to us about a legal perspective and who should we trust with Australia's publicly funded data. So without any more ado, I should mention that if you've got any questions to ask of Carolyn, you can type them into your question box anytime during the presentation, and at the end of the presentation we'll ask Carolyn all of your questions and she'll be more than happy to answer them for you. So without further ado, welcome Carolyn. Thank you very much, and I will hand over to you.
Thanks, Felicity. That's really lovely. Thanks for the invitation to represent this material as a webinar on who we should trust with Australia's publicly funded data. I'm delighted to be involved in this conversation, and it is really just a conversation which has only just begun, so everybody's very open to new ideas and approaches. I've been working on these issues for a number of decades now, which sounds wrong but is true. So first with the Federal Attorney General's Department in the 90s, then with the Australian Law Reform Commission in the 2000s, and finally with for the last 10 years as an academic at Macquarie University. And as Felicity mentioned, I also had the privilege of working with the PHRN back in the day. And the learning curve, which started very steeply with the work with PHRN, never has really flattened out. So the subject of data, and in particular data linkage research, continues to challenge and surprise me. And as we move forward in our technological capacity to link and use data, new issues of fundamental importance continue to arise, and we're going to consider one of those today. My colleague Annette Brownick-Mayer from the University of Wollongong and I were asked to reflect on trust and the issue of who we should trust with Australia's publicly funded data. Annette will be considering the ethical aspects of this question in next week's webinar, so tune in for that. This week I'd like to touch on some of the legal aspects of this question. But just before we consider who, I'd like to consider the term trust. Trust is foundational to all human relations and to sharing of any sort. That's why it's important to sharing data, our subject for today. Sorry, I'm just trying to click. Oops, too far. All right, here we go. So to begin at the beginning, what is trust? As always, when I'm faced with a complex question like this, or a sort of foundational issue, I turn to the philosophers for insight. They've spent literally thousands of years considering this issue of the meaning of the terms like trust, and so who am I, an administrative lawyer, to try and work it out on my own? So Carolyn McLeod, a Canadian professor of philosophy, notes that trust is an attitude that we hold towards other people whom we hope will be trustworthy. So trust is this three-part equation that we see here on the slide. That is, A trusts B to do X. Trust is important because it allows us to form relationships and to undertake cooperative activity, such as collecting, sharing, and using data. But it's also dangerous because it involves risk. The risk that those we trust will let us down. If there was no risk of this sort, if we knew that B would do as expected, then trust would not be required. Trustworthiness is a different concept. Trustworthiness is not an attitude. It's a property and it can be demonstrated. MacLeod tells us that a trustworthy person must be two things. They must be competent. That is, they must have the relevant skills to do the job. And they must be committed to doing the job. So competence and commitment. There's much philosophical debate about what this commitment looks like and whether or not a trustworthy person must be properly motivated. And I understand that Annette will be discussing this element, the commitment element, in further detail next week. But there's agreement that even if someone is trustworthy, there's still an element of risk. Trust is dangerous because of the risk that those we trust will let us down. So Health Engine, Australia's biggest medical appointment booking app, appears to have done just that. The Australian Competition and Consumer Commission, or the ACCC, has instituted proceedings in the Federal Court alleging that while consumers were led to believe that their personal information would stay with Health Engine, it was in fact being sold off to private health insurance brokers for a fee. MacLeod notes that we need to seek to mitigate this sort of risk by imposing conditions or monitoring behaviour. Indeed, if we think about privacy and consumer protection legislation, they do just this. They do impose conditions, and regulators like the ACCC do monitor behaviour. But the more conditions we impose and the more monitoring that goes on, the less that actual trust is involved. On the other hand, the more conditions we impose and the more monitoring we do, the less vulnerable we feel because we feel we are reducing the risk. So I'd like to move on now from philosophy to consider the way that lawyers view trust. So as you can imagine, lawyers are fairly sceptical about trust per se. When a lawyer speaks of trust, we don't really mean trust. What we really mean is a legal construct that is tightly defined and highly regulated. In a legal trust, someone, that is the trustee, holds property or assets on behalf of and for the benefit of the beneficiary. Because the beneficiary is vulnerable in this arrangement, legal obligations are imposed on the trustee to act in the best interests of the beneficiary. It's significant to me that these obligations are imposed on the trustee under the law of equity. Where property is held on trust, the duties of the trustee include to preserve the trust property against loss, to act in good faith, to exercise reasonable care, to be accountable and transparent. In addition, a trustee must not obtain any unauthorised benefit from the relationship or be in a position of conflict of interest. Now, I'm not suggesting that data custodians, and perhaps researchers as well, are trustees in this strict legal sense. But I am suggesting that the principles that underpin trust law are of interest because they recognise and respond to vulnerability. They seek to protect the interests of the vulnerable party. In fact, I think that most data custodians and researchers would recognise and acknowledge that they also have these duties. The essential principle is that the trustee is acting on behalf of the beneficiary and so must act in the beneficiary's best interests. Under this model, those who hold the data, for example, the data custodians, do so as trustee. The community is vulnerable in this relationship for a number of reasons. First, the community's data is often collected without consent, for example, where the collection is required by law into a cancer registry or some other registry. Even where data is collected with consent, for example, at a hospital admission, the secondary use of the data for research is very often without consent, sometimes even without the knowledge of data subjects. In making decisions about how this data is used, data custodians are acting on behalf of the community, that is, the data subjects, and thus should be required to act in the interests of that community. In any event, public officials, such as government data custodians, are required to act in the public interest. They must perform their job and make any discretionary decisions, such as whether or not to release data for research, in ways that promote the public interest. This is because the institutions of government and the officials and agencies of government exist for the public, to serve the interests of the public. It's not therefore surprising that we are more or less comfortable with the idea that government data custodians should be required to act and make decisions in the public interests and in the interests of the community. So the question is, what does public interest mean? It's a complex term and it's context specific. So you would need to make a decision on what's in the public interest in relation to a specific set of facts. But it's important to think about what the public interest might be in terms of what it is not. So here's a definition from the New South Wales Ombudsman. You must perform your duties in ways that are consistent with matters of broad public concern and away from private, personal, parochial, or partisan interests. So these are things you must not take into account when you're making a decision in the public interest. The NH and MRC principles for accessing and using publicly funded data for research make clear that data custodians should recognise their responsibilities and accountability, including protecting the privacy and confidentiality of the data. The principles also underline the importance of due respect for data subjects and the need to incorporate consumer and community involvement in the decision-making process. So far, so good. Principle 1 is to maximise the use of publicly funded data for the benefit of the Australian community. The second principle encourages data custodians to recognise their responsibilities and accountability. They're to encourage and support access to data while protecting the privacy of individuals. What I think's missing from this statement of principles, however, is some robust statements about how publicly funded data is being held on trust for the Australian community. That seems to me the starting point rather than maximising the use of the data. Yes, it might be implicit in the principles or other documents that data custodians must always act in the public interest, but it bears restating here, I think. And what of our university researchers? Do they hold data on trust for the community? Are they bound to act in the public interest? Almost all of Australia's 43 universities are established under federal, state legislation. So they're statutory corporations governed by their enabling legislation. This gives universities a certain independence from government, much like statutory agencies such as law reform commissions. And it's clear legally that public universities are required to carry out public functions of higher education and research for the benefit of the community. They do therefore have a public interest brief. In addition, the national statement provides that all research involving humans must proceed on the basis of respect, research merit and integrity, justice and beneficence. These requirements are intended to shape a relationship between researcher and research subject built on trust. But a direct and trusting relationship of this kind is not possible where a waiver of consent is sought, for example, for data linkage research. In this case, a Human Research Ethics Committee is required to decide a number of things, including whether the public interest in the research outweighs the public interest in preserving privacy. This is a clear requirement that any such research must be in the public interest. In this case, the Ethics Committee is responsible for making a decision on behalf of the community. Because of this, researchers are required to conduct research that is in the public interest. All of this activity takes place in the public sphere, and so far the drivers have explicitly included the public interest. That's why I think there's a level of trust extended to government agencies and universities to conduct research on behalf of the community. But it's important to remember that this trust is underpinned by obligations of transparency and accountability to the community. And it's also important to remember that this trust is not unconditional and it can easily be damaged through lack of engagement with the community. See my health record. And lack of competence leading to data breaches. See multiple data breaches. But what of the private sphere? Before closing this first part of the presentation, I'd like to touch on this next frontier. Can we trust private industry to use Australia's publicly funded data? They are certainly interested in doing so. Big Pharma would like to access data to see, for example, how medicines perform in the real world, so post-market research. And this definitely sounds like it would be in the public interest. The confusion around the issues, however, was illustrated during the development of My Health Record, when the Deputy Secretary of the Department of Health stated in evidence to a Senate committee that researchers from private companies could seek access to data, but it could not be used for commercial purposes. She said they're not precluded as an applicant so long as it's for public health research purposes. And I'd like to interrogate the tension between those two ideas a little further before closing. Where does the tension originate? Well, it arises from the Corporations Act, and it's referred to as the shareholder primacy norm, and you can see it here. Directors and other officers of a company are legally required to exercise their powers and discharge their duties in good faith in the best interests of the corporation. In addition, they must not use their position to cause detriment to the corporation. What this means in practice is that the primary consideration of directors and other officers must be the best interests of the corporation. Of course, this doesn't completely preclude any consideration of public benefit. Some consideration of public benefit is obviously in the best interests of a company. It gives rise to profit, as well as establishing and maintaining the social license for the company's operations and enhancing the company's reputation. But producing a public benefit is not the same as acting in the broader public interest. We can't ask companies to consider the public interest in the same way that we require government and public universities to consider the public interest. They are simply not designed to do that. Instead, they're required by law to consider the interests of the company and the shareholders as a priority rather than the wider community. Therefore, is it reasonable to ask a corporation to act as trustee for the community's health information? Suggestions do emerge from time to time that corporations law should be amended to require some duty to the public, but that has not happened yet. In addition, there are moves to amend the Corporations Act to allow an opt-in status for companies to extend their purpose, allowing a general public benefit to be considered. This is referred to as the triple bottom line of profit, people, planet. This model is referred to as benefit corporation, and it's available in some jurisdictions, many of the states in the US and British Columbia in Canada, for example, but it's not yet available in Australia. When we ask research, when we require research that is impartial and independent, researchers must be acutely aware of potential or actual conflicts of interest. University researchers are asked to declare such conflicts and to develop strategies to address them. There is no question, however, that private sector companies conducting research and development are conflicted in the relevant sense. They have a direct financial interest in the outcomes of the research. The question is whether strategies to address such conflicts, for example, partnering with university researchers or monitoring of research by independent reviewers, are sufficient to ensure that the research is impartial and independent and results are reported in full. That is, that the research is conducted in the public interest. These are some of the legal issues involved in sharing government health information with private industry, and I'd be delighted to discuss any questions or thoughts you might have on that as we go forward. Thank you.
So thank you very much, Carolyn. That was a really interesting and stimulating talk. Now, just remind people that if you'd like to ask Carolyn a question, you can just type the question in the question box and I'll be able to read that out for her. But first, maybe I'll start with a question or two. Clearly, public interest is, or determining what's in the public interest is an enormous challenge in helping us decide what we should use data for and what we should not use data for. And it's very hard to find a definition of what the public interest actually is. So my question is, should we have a definition of public interest, or is it better to leave it as this sort of nebulous concept?
So that issue clearly has been considered by inquiry after inquiry and by the courts over and over, and the general consensus is that it's not helpful to try and define it because it's so context specific, but to define it in the negative. So put aside your personal, family, corporate interests and make a decision that's in the interests of the broader community. And this is where that tension arises between acting in the public interest and acting for a narrower sector of the community, for example, for your shareholders. Now, whether the interests of shareholders and the interests of the community can align, sometimes that happens. You know, there is an alignment. But the concern is that because a private company is required to act in the interests of this narrower sector of the community, it's sort of precluded, in fact, from acting in the broader public interest. So I would say, based on the research that's been done in the past, no, it's not helpful to define it except in the negative.
And just going on to sort of tease out that tension between, well, the concept of whether the interests of a company could align with the public interest. If you're thinking, for example, in the development of new therapeutics, for example, or pharmaceuticals, quite clearly, new effective drugs and treatments can definitely be in the public interest, and yet pharmaceutical companies will make a lot of money out of a good drug that they can sell for a lot of people. Is that an alignment, or is it not?
It could be an alignment, but I suppose my concern with that scenario is whether the research into the condition or problem canvassed and considered carefully solutions that weren't going to be profitable. So if your research is completely at large and you come to the conclusion that a very simple solution, which is not highly profitable, is the best solution to that problem, question mark whether that's in shareholders' interests to make those findings public, or whether it's in shareholders' interests to go down the route of a more expensive solution because it's more profitable. And I feel like that's the tension there between the interests of shareholders and the interests of the community more broadly. And it's where I'm concerned that the drivers for corporations almost preclude the interest of a consideration of those broader interests of the community.
Felicity, we've got two questions here.
Yes, I've got them now. So we've got some questions. I can read them, Nicola. Yep. So the first question is, should there be a commissioner who has oversight on public data, such as health community data sets? Currently, in the name of national security, government can access any data of an individual without warrant or due process and diligence. Also, the lobby factor of private sector to government for access to individual data for commercial gain. Your views?
Okay, so
the first part of that again?
There's three questions there, so let's take them one by one. Should there be a national commissioner responsible for oversight of the national, the data sets of personal health information? My view is yes, and that there are a number of commissioners who have responsibility in that area. We have the newly established Data Commissioner, National Data Commissioner, who's responsible for oversight of access to and use of federal government data collections, including collections of health information. The National Data Commissioner is at this very moment considering the question of whether or not it's feasible to provide access to those data collections for private industry. So it's a really live topic, and if you had views on that issue, the Data Commissioner, the National Data Commissioner, is the place to feed those views in. It's a bit of a topic in development. That's why we're talking about it today. The other commissioner who has responsibility in this area is the Australian Information Commissioner. So the Australian Information Commissioner administers the Federal Privacy Act, which, as you know, probably regulates access to and use of some of those health information data sets. So there are a number of commissioners, both at the federal and state level, with responsibilities in this area. Some of the critiques of those commissioners in relation to private industry access to data are, for example, that the Federal Privacy Commissioner is not well enough funded to handle complaints from the public about misuse of data, and that we don't have a dedicated privacy commissioner at the federal level. So that's an issue for a lot of people. Other than that, the departments themselves have responsibility for ensuring that their data sets are handled appropriately. So there's a lot of regulatory oversight of the use of the data sets. It's not that they're unregulated or uncared for or unloved. There's a lot of regulation there. Now, Remind me, Felicity, what was the second part?
So there were two parts. We might actually go to the third part next, which was really asked for comment about the private sector lobby factor, that private sector lobby government for access to personal information for commercial gain.
Yes, so it's completely within the normal role of a corporation to lobby government for benefit. And I don't see anything wrong with that per se, but we need to think very carefully. This is why I've been over the Corporations Act provision, because we need to be very clear-sighted in dealing with corporations and to understand that they do not act in the public interest. So the decision about what is in the public interest is the responsibility of government. And they need to make those decisions with the interests of the whole community on the table. So a company can lobby, that's what companies do, for access, but whether or not they gain access is a question for government. And at the moment, when a researcher asks for access to a data set held by the government, the researcher must establish that their research is in the public interest. Now, I'd just like to highlight that research being in the public interest is a higher bar than research having a public benefit. I have no doubt that pharmaceutical companies can demonstrate that research into a cholesterol medication is likely to have public benefit. My question is whether a company that is primarily driven by the interests of shareholders can genuinely claim that the research they're conducting is in the public interest, the broader public interest. So that's where we need to be a little bit careful, I think.
Yeah. And now there was a third part to that, but we've actually got a couple of other questions and I'd like to get to them before we finish. So I might just move on to the next one, which is just wondering how difficult it is to determine what's in the public interest and when there are conflicting ideas about what's appropriate data use in relation to a broad range of research, service delivery, evaluation, etc. So yeah, how difficult is it?
It's very difficult. So government every day is asked to consider what's in the public interest, and that's where we have hours and hours and hours of debate in Parliament. But perhaps a bit closer to home, anyone who's sat on a research ethics committee knows how difficult it is. So research ethics committees are asked every meeting to make decisions about what's in the public interest. And to do that, they gather as much factual information about the research and the risks and benefits of the research, and they weigh those risks and benefits and try to come to a conclusion about whether the risks or the benefits outweigh the risks, and what interest is being served by the research. And one of the questions that they have to ask is whether the particular research has a conflict of interest in the outcomes of the research. And the reason we ask that is because if a researcher has a conflict of interest, i.e. a financial interest in a particular outcome, we question whether that researcher brings to the table an unbiased view of the potential outcomes and will be motivated to explore every potential outcome in the public's interest, whether it be, you know, for example, if the answer to the research question is do nothing, or the answer to the research question is eat less, or the answer to the research question is Panadol would fix it, nobody's going to make much money. Well, eat less, I guess the dietary industry might make money out of that. But, you know, sometimes you have to be open to the non-profit answers to your question. And I think that's where the tension arises with the private sector industry moving into this sphere.
Okay. And then final question. Thank you for a very interesting discussion of these issues. You mentioned the triple bottom line. Is this likely this framework will be adopted by the Australian government in the future?
I think there's a high likelihood that they will go down this path. So there's funnily enough, a lobbying organisation has been established to lobby government to allow corporations to be set up in this new model. And it's quite a progressive movement. I think it would actually shift the way that corporations operated. Whether you can balance profit making and public interest is an interesting question, but at least it would allow companies to put public interest in as one of their considerations in whether or not what sort of research and development they do and how they progress their businesses. So I think it's a positive. Yes, I think eventually it will happen in Australia. Whether it's enough for everybody to feel comfortable that these precious community assets, that is the community's health data held in data sets in the government's hands, whether it's enough to reassure us that the research that would be conducted on the basis of that data using that resource would be in the public interest. I'd still put a question mark over that, but I'm almost certain that not sure, maybe midterm, but moves are afoot to try and get these changes to corporations law, and I think it would be a really interesting development.
Okay, well, that's the end of the questions. Thank you so much, Carolyn, for your presentation today. It's been fascinating, and it's a really important conversation that is at the forefront of the conversations in this area around the country at the moment, from the Commonwealth Government down, and so we're very interested in keeping abreast of what's happening in this area. The video of this presentation will be up on the PHRN YouTube site in the next couple of days. You'll get an email to let you know when it's available if you've registered for the webinar. And I'd also like to encourage you all to come back again next Wednesday to hear Anna Brunnick-Meyer from the University of Wollongong give the ethics perspective on trust. And that should also be an equally interesting presentation. We look forward to seeing you all again next week. Thank you very much.
Thank you.